talking about trial, getting ready for trial, and trying a case. I'm going to talk about some abstract concepts and some concrete concepts that support our approach and method and strategy for getting ready for trial and then executing in trial. The first abstract concept that I'm going to talk about, the big one, is anxiety. Anxiety is a driving force in a courtroom. Everybody has it to a degree. Lawyers have it, no matter how many cases they've tried. And every witness has it to a degree, no matter how experienced the witness is, no matter if they're an expert or if they're a party to the case. Anxiety is heightened if you're a party to a case because, one, testifying by itself is not ideal, it's not desirable. All other things being equal, if you give someone the option to testify in a case or not, a normal, rational person should choose not to because you're on the stand, you're under oath, and you're exposed. You can't predict the questions that you're going to be asked, and you have to answer them truthfully, and you have to answer them in a way that's not just truthful, but believable. And it's even worse if you're a party to the case because everything you say can affect the outcome that you have an interest in, the outcome that you have a stake in. So anxiety is a big factor and influencer in behavior in the courtroom and in why someone would or wouldn't want to testify. It's also a factor in how we assess our evidence and what we're going to do in trial. I'm going to tell you a little bit more about that. We're going to move more into some concrete concepts and skills. So our system is an adversary system. And the idea behind our system is that each side is going to marshal their evidence, they're going to cherry pick their facts, and they're going to make their best case, they're going to make their best defense to the judge or the jury. And out of that clash between those two perspectives, between those two selected facts, the truth will emerge because each side is so hostile to each other, at least in their goals and desired outcome, that they will not only put on their best case, but they're going to challenge the other side's evidence to the best they can so that the fact finder can decide who's telling the truth, which story is more believable, and what's the best outcome for this situation. So that idea affects the believability of a party's testimony. I'm going to tell you a little bit more about what I mean by that. Okay, so we've already talked about anxiety, and each side to a case is experiencing anxiety to a degree. Out of that adversary system, in that process, in the courtroom, the judge and the jury know. They recognize as this process gets started, even if it's a juror's first and only time in a courtroom, that as a lawyer, I am a hired gun for my client. This is called sponsorship strategy or sponsorship theory. And they know that we are going to make our best case. We are going to use our best choice of words to try to maximize the value of our evidence and to try to get the best outcome possible for our side. And we don't want to help the other side at all. So what that means for our client is this. There is a barrier to credibility or an inherent skepticism by the judge and the jury for anything that our client says when we are questioning our client. They know that me and the client are working together, even if we haven't rehearsed. We have planned for this, we have strategized, we are putting our evidence out in the best order that we think will help someone understand it and be inclined to rule in our favor. So even if our client testifies as the most credible, believable person, honest, trustworthy, there's still that barrier to credibility because they know we're using our best word choice. They know we could be leaving out some context, and we're allowed to do that. We're only required to make the best case that we can. Now, this barrier to credibility is made worse by anxiety, and it's also made worse by the rules. And I'm going to show you about that. This is a technical rule that applies in every case. When we are questioning our client, That's called direct examination. And in direct examination, you are supposed to use only open-ended questions with very limited exceptions. How, what, when, why, where, who. None of these questions can be answered yes or no. And there's a reason for this requirement. The law is recognizing, the rules of evidence are recognizing that I am the hired gun, I am the agent for my client. So the rules are not going to allow me to do the testifying. They're not going to allow me to use leading questions and suggest to my client what to say. So I have to use open-ended questions. None of these questions can be answered yes or no. And these questions are designed to shift the burden of the storytelling away from me, their agent, and to put it on the client. So the client now is being given this burden of telling the story with open-ended questions that can't be answered yes or no, in a climate where everything they say is being viewed with skepticism, and they're experiencing the anxiety and the pressure of testifying like any witness does, except this witness, the client, has a stake in the outcome, so it's even worse. And the compound effect of those factors can be crippling, and everything's being viewed with skepticism, and the client knows if I say the wrong thing or if I'm perceived the wrong way, I may lose the whole case in just a couple of words. Now, here's some good news. All these factors are true for the other side as well, in any kind of case. Each side has this problem. The rules also recognize this dynamic in our adversary system. So the rules are different when a lawyer is questioning the other side or a witness for the other side. That is called cross-examination. In cross-examination, the law is recognizing we are not on the same page, me and this witness. And if given the opportunity, this witness is going to reject the things that I want to prove. If I don't word it just right, and if I'm not prepared, the witness is going to deny what I asked them because they don't want to do anything to help my side of the case. So I'm allowed to ask leading questions and to prove facts. If I have my act together and if I have done my preparation, I'm allowed to prove facts for my case through the other side on cross-examination. I'm going to give you a crude example. You walked out of your house, you closed the door behind you, you locked the door, you walked to your car, you got in your car, you started the engine, you backed out of the driveway looking in your mirror, and you looked over your shoulder, and then as your car got on the street, you drove away from your home. Those are questions on cross-examination that must be answered yes or no. And I'm going to contrast that on direct examination. Where were you? What did you do? What did you do next? What did you do next? What happened next? Where did you go? You see the difference there? Those are open-ended questions versus the lawyer is actually testifying on cross-examination. And if the lawyer has done their homework, they can tell the story and give a lot of detail that the opposing party has to say yes or no to. The barrier to credibility or the skepticism that I talked about when a lawyer is questioning their client doesn't exist on cross-examination because in our adversary system, the judge and the jury recognize that the witness is hostile to the lawyer. They are adversaries. They are not attorney-clients. The attorney is not their agent. And so that witness, that opposing party, is not going to say yes to anything that is not true. They may not say yes to things that are true, depending on the way it's worded and depending on how bad the witness wants to behave. But they're going to be very resistant, if possible, to saying yes. What that means is anything they do say yes to is an absolute admission. There's no barrier to credibility. It is accepted by the judge and by the jury as absolute truth because of the difference in the dynamic, because it's the opposing party. So when we're assessing our evidence, we look at the case, the evidence, the witnesses, how much can we prove through the other side. This is a skill set. There are technical skills to cross-examination and soft skills for cross-examination, and we spend a lot of time working on and developing that skill because of the value of proving facts. Again, that contrast, that little example I gave, whether you're going to prove that they left their house and their car on direct, or you can prove that they did it on cross-examination, you get more bang for your buck and more value out of facts that you prove through the other side using leading questions. Now here's a little caveat. This is where lawyers mess up. Most lawyers know the rule or the idea that they can use leading questions on cross. But they're also allowed to use, if they want to, open-ended questions on cross-examination. And that is a mistake. That is something that we do not do, and we work hard to frame our questions as leading. If you are using open-ended questions on cross-examination, you are giving away your most powerful tool, and you are telling the jury, listen to their version of events. I'm going to ask them how, what happened, explain. And if you do that with the opposing party, they are going to get you. Their mind will recognize the opportunity that you have just given them, and they will give you an answer that will utterly harm your case. So you have to really be skilled and disciplined on cross-examination, and if you do that, and if you put in the prep time and structure your cross-examination, you can win your case by proven facts through the other side.